Hello, John. Nice to see you.
Hello. And
Yes, I didn't want to miss this. I was just at a Rotary meeting,
mm,
the Union Club here in Victoria, and racing home to be here on time.
excellent.
Hello.
Hi.
Hello,
Hi.
Rebecca.
Hi. Just getting started here. Nice to see you, John. And
Y-
folks. John, would it be helpful if I share the slides?
That would be.
Okay, great. I'll just get that set up. So just give me one moment. It's precisely 12 o'clock right now. So if you just bear with me.
Okay.
I apologize, but the source of my delay this morning is I can't get into my Outlook. John, would it be possible to put the slides in the chat?
I can share my screen as
Oh, can
well.
you? Okay, I will
I've
do
got
that
everything
just to make it
available, but
easier.
just because
Um,
the privacy commissioner's on the line, I'm going to minimize some stuff. Uh,
Okay, great. I will make you a co-host. Um, it's a fascinating thing that somehow I can't get into my email today at this moment.
it is one of the great mysteries of life,
Yeah, okay.
why the internet never works when you need it to, and
I mean, it
etc.
was working before, but anyway.
Okay.
So, um, is it working?
I can share screen. Just,
Thank you.
all right. All right, you should be able to see the screen.
Wonderful.
Um,
So
and I
if
will put it into presentation mode once we're ready to go.
I I think we're all set. And so without any further delay, and again, I apologize, I wanted to thank John McLean, who is with the government of Nunavut, and probably known to many of you, for launching off our Lunch and Learn series. With the Law Society of Nunavut, we will be hosting a number of Lunch and Learns this year, and this is our first one. So thank you to everyone for being here, and thank you especially to John for launching us off and supporting your peers in the bar in this way. And we will have John back later on this month as well for a second go round on a different topic. Today, he's going to be talking about emergency laws, which is a topic that is not at all obscure in the wake of COVID. So with that, I won't belabor it, but suffice to say, we're very grateful that John has agreed to make this presentation today.
All right, thanks, Rebecca, and thank you all for abiding with the change in date. I was just back from annual leave last week and had definitely bitten off more than I could chew in giving a presentation in the same week, trying to clear a bunch of emails and, of course, cabinet deadline week, etc. So, without further ado, I'm a lawyer, therefore required to give you a disclaimer that the information in this presentation is intended for educational purposes and is not legal advice. And the opinions and analysis in the presentation are my own and are not necessarily that of my employer. And with that out of the way, we're going to talk about the emergency legislation in Nunavut. We are focusing on territorial legislation today, specifically the Emergency Measures Act and the Public Health Act. But naturally, this being Nunavut and the nature of emergencies, there is some overlapping concern about federal jurisdiction and how we address that. And we also are going to speak about charter considerations and other constitutional considerations. And then I'm going to shamelessly plug a program that I'm delivering. I'm a part of a panel at the end of the month with Osgood Professional Development, and strongly encourage you to see the federal side and also more recent commentary on the federal court decisions, which I'm not really going to talk about today. We're really focusing on territorial acts today. So, an overview of emergency legislation in Nunavut. Primarily, we're looking at the Emergency Measures Act, which is post-division. It was enacted after division from Northwest Territories in 2007. There is the Public Health Act, an act I am intimately familiar because I was part of the team that advised on its development, and it came into force on January 1st, 2020. So just in the nick of time for the COVID pandemic. And I was part of that response within the GN for the 2 years that we were doing that. And so those two acts are our focus for today. But you also need to know that there is federal legislation that exists in this area. There is the Emergencies Act, of course, which anyone following news about convoys and border blockades and whatnot will have been following. And of course, there was a federal inquiry on that, the Rouleau inquiry, which the report is out, and you can read that. There is the Emergency Management Act federally, which is it's a useful act because it requires the federal government to have plans and procedures and to test those plans, but it is also the vehicle by which the provinces and territories can request assistance from the federal government for civil emergencies and civil disasters. There's also the Quarantine Act, which was brought in after SARS. Remember SARS in the early 2000s when it realized that our rules about entry to Canada and testing people were not up to snuff. So the Quarantine Act came in, and that is the act under which many of the federal powers came in during COVID and various other public health emergencies. But federal legislation is really a topic for another time. We are really focusing to keep this to an hour, because those of you on the call who've met me before know I can talk till I'm blue in the face. So I am trying to keep this limited. So what's an emergency? Let's define the terms to begin with. It's a present or imminent situation that is seriously affecting or could seriously affect the health, safety, or welfare of persons, or is substantially damaging or could substantially damage property. That is the definition out of the Emergency Measures Act. So obvious examples, and every one of these things on the screen has happened in Nunavut. So the first thing you think of when civil emergencies, your declaration of state of emergency, you hear flood, disaster, severe storm, natural disaster, hurricanes from my part of the world in the Maritimes, wildfires. Our friends in the Northwest Territories have certainly been through that, as well as our colleagues and friends in the Western provinces. Last year was terrible for fires, worst in our history. We actually had a forest fire in Nunavut, if you could believe that, up in Bathurst Inlet. So we actually had our first ever declaration of a state of emergency for a forest fire last year. Equipment failures at water and wastewater treatment plants. We had all of the water go salty in Senekilowak, for example, and the groundwater became contaminated. We don't know why. And so we ended up having to install reverse osmosis filtration in every house in Senekilowak. That was a state of emergency that was declared. Contaminated drinking water. Those of us who lived in Iqaluit have fondly remember a time where we couldn't drink the tap water for 3 months, and we had to stand in line for bottles of water. That we bought so much water, it put it was so heavy, the warehouse floor collapsed. Just saying. Fires at critical infrastructure. So schools, power plants, health centers. Some of you may remember that time we had to charter an Antonov heavy lift aircraft to bring a helicopter and emergency generator equipment into Iqaluit so we could fly it to Pangertung to get the lights back on. That is still the best overtime I've ever done. Getting called in on a Saturday to charter a giant airplane. It was great. We got the lights back on in record time, which was fantastic. Plane crashes. Unfortunately, we have experienced those in Nunavut, and there have been emergency responses associated with that. And of course, the COVID-19 pandemic is the most recent thing that we all lived through in our own various ways. So let's start with the civil disasters and the Emergency Measures Act. And there are two main features of this act that come up all the time, and those are local states of emergency and territory-wide states of emergency. So the Emergency Measures Act is administered by CGS, by the Department of Community and Government Services, and the ministerial powers are exercised by the Minister of CGS. CGS contains within it the Territorial Emergency Management Office, or EMO, and they coordinate the emergency response from the GN, but also work with municipal governments in their emergency responses as well. So there are provisions. If you look at the Emergency Measures Act, there's an obligation for the GN and for every municipal government in Nunavut to have emergency management plans, to identify risks, come up with ways of mitigating them. This is all very useful stuff. And this is all things that every emergency management expert will tell you that you should do as just competent planning. Every risk management person you'll talk to will tell you it's a good idea to have these plans. Those provisions respecting the GN's emergency plan and the municipal plans are not yet in force and have not been brought into force since 2007 when the act was proclaimed. When those will be coming into force has yet to be announced by the Minister of CGS, but it will require every municipal institution and government institution to have a plan. So in a territorial emergency or territorial state of emergency, the order is made by the Minister of Community and Government Services. So it's the Minister of CGS issues the order. It lasts for 14 days. That is the statutory period that a state of emergency lasts. It can be renewed for the duration of the emergency. And the minister can declare that emergency exists in all of Nunavut or in just a part of Nunavut. And that could be within municipal boundaries, which is typically what we see. But for the Bathurst Inlet situation, for example, Bathurst Inlet is it's not a municipal corporation. It's not a permanent settlement, but it is an area of Nunavut or a part of Nunavut. So it had to be declared for a part of the territory. So the minister's powers, I will absolutely not read statutes to you. You're grown-ups, you're lawyers, you can read statutes. The powers are set out in Section 13 of the Emergency Measures Act, and includes a very long and detailed list and measures that the minister can do or can direct others to do. But the first bullet there is the important one. Like that's the one that comes up more than anything else. It's procuring supplies and equipment. The primary use of an emergency declaration is to facilitate procurement. It's to make it easier for us to buy things quickly without having to go out to tender. It allows us to facilitate the purchase and delivery of materials and supplies when they're most needed, to whom they're most needed. So that is largely why we do it. It opens the door to some areas of government procurement that are typically not used. But there can also be controls on travel to and from places in Nunavut. You can authorize, render qualified assistance. You can coordinate essential services. There are things like fixing prices on essential goods and services and conscripting others into service. Basically, hey, you go fill that sandbag, that have never been used in my tenure in Nunavut. The powers exist and there would have to be an order around it. But those are powers that have yet to be used because generally people in Nunavut during a crisis, everybody pitches in anyway and don't need to be told.
We just wanted to ask you if you wanted to show us the slides as part of your presentation.
Are you not seeing the slides?
Well, there's just the one slide, the title, that's all that we see.
I think it might not be in presentation mode.
Oh, okay.
Are you advancing the slides?
I am. Yeah, sorry, folks.
They haven't been advancing.
All right. Well, let me see what I can do here. Yeah. I said I am screen sharing.
Because all we have is the title.
Okay, I'm sorry about that, folks.
There we go. That is now working. Thank you.
Okay. So are you seeing a slide that says state of local emergency?
Yes.
Yes.
Now we are.
Yes.
Yeah.
Okay. So, all right. Thank you for pointing that out, folks. In a state of local emergency, it's made by the declaration is made by the municipal council. So city council in Iqaluit, hamlet council in the other 24 communities. The duration is shorter. It's a 7-day declaration, but it can be renewed. But here's the thing that comes up and that our former mayor did not necessarily understand during the water crisis, that if the Minister of CGS declares a territorial state of emergency, it automatically cancels the municipal declaration. And also the Minister of CGS can cancel a declaration of a local state of emergency if the minister determines that the criteria for a declaration are not met. Again, that's a break glass in case of emergency kind of power, but it does exist for the minister to do. And again, the municipal state of emergency could apply to all of the municipality or just part of it. And in my experience, it applies to the entire, it has applied, everyone that I've been part of has applied to all of the municipality. So the contents of the declaration, whether it's a territorial declaration or a local declaration, it has to state the nature of the emergency, the part of the community where the emergency exists. It's also going to have some preamble language typically declaring why the minister is making the decision that they're making or why the council is making the decision that they're making. And that has the declaration of a territorial state of emergency has to be gazetted, has to be published in the Nunavut Gazette, which I know all of you read faithfully. And it does have to be published in places where people might actually read it as well, other than lawyers. It would have to be, it's typically sent to media. It's typically published on the GN's website or on social media, like any way you can get it out there. And because this is Nunavut and we have an Official Languages Act, it has to be published in all the official languages. The Gazette is English, French. The wider publications are in all the necessary official languages, because people have to understand what the laws are and how it affects them. So municipal council's powers in a local state of emergency are shorter, and they are a narrower set of powers. They don't have the power to order people to they can't conscript people, they can't set prices, they can't do that. But they can authorize qualified persons to render aid and assistance, so they can coordinate emergency response from like first aid or from flood mitigation, that kind of thing. You know, just in case, say, the landfill catches fire and they let it burn for 4 months, because that's happened. You bring in a specialized firefighting team to put the landfill fire out. It's an authorizing people. It also, again, speeds up local procurement. So that's the local states of emergency, and they are generally used for the things that you think they're used for. It's the natural disasters, the physical disasters, the failures of systems can be an emergency situation. And that's how they've been used in Nunavut. The one that we are more familiar with in recent years is the Public Health Act. And this is used for something called a public health emergency. And we have possibly one of the most advanced public health acts in Canada because it is among the newest. We are, along with Newfoundland and Labrador, we were amending our act kind of in parallel. And Nova Scotia's is around the same age. And so some of us were all doing responses to public health acts. And those public health acts were amended largely as a result of the SARS pandemic in the early 2000s and the H1N1 pandemic in 2008, 2009, whatever year I was articling. There was a public health crisis declared in Ontario because of H1N1. And every one of these disasters or these emergencies that follows, there tends to be a royal commission or a series of commissions or studies, and there are recommendations for best practices. In fact, my foray into this, if we're doing John's ancient history, I started working on pandemic preparedness as a law student, as a summer student working in New Brunswick at the Department of Health. And 15 years later, still here. So, but it is something that, it doesn't go away. These emergencies will not go away. And we do have to know what they are and how to prepare for them. So Public Health Act, the Minister of Health and Department of Health are really the coordinating agency within public health emergencies, but the powers really do center around the Chief Public Health Officer, or CPHO for short. The CPHO is an appointment of the minister, and it is a 5-year good behavior appointment because the CPHO has to have the ability to order the government to do things they don't necessarily want to do, i.e. spend money. No government likes to be told to spend money, but the CPHO can order us to do things that that are necessary to respond to public health emergencies. The CPHO's role is much larger than just responding to emergencies. They are sort of the doctor for the population. Their client is the entire population of Nunavut, and they deal with disease outbreaks, tuberculosis and other communicable disease. They coordinate things like restaurant inspections as well. Like, there is a day-to-day role for the CPHO and their office. But today, just to keep this presentation to an hour, we're going to talk about what they do in emergencies and how they respond in emergencies. So a public health emergency is an occurrence or imminent threat that poses a serious risk to public health. That is the definition in the Public Health Act, and it includes the disease outbreak in either humans or animals or both, includes pandemics, includes things such as water and sewer system breakdowns, again, because that does happen, and we have chemical spills as well, would also be a public health emergency. The one we're most familiar with, there was a declared state of public health emergency to deal with COVID, coronavirus 2019, because it was declared by the World Health Organization to be a pandemic of serious concern. Public Health Agency of Canada followed suit. March the 20th, 2020, the government, the Chief Public Health Officer for Nunavut declared it to be a pandemic in Nunavut. March 24th, 2020, we declared a public health emergency, which lasted until April 11th, 2022. And on April the 13th, 2022, I hit the beach in Bermuda to start recovery.
I think you've had all of those things happen in the last few years.
Yes, we have. So this is possibly why I'm the guy who can talk about emergency law now. So the Declaration of Public Health Emergencies made by the Minister of Health on recommendation of the CPHO. That declaration gets gazetted, but the minister's order, the CPHO's orders do not have to be gazetted. They have to be published. And they were routinely published, and they have to be explained to the public in a way that they can understand them. This is why we had those briefings in the early days of COVID, where if you didn't already appreciate interpreters, I think those of us who practice law and live and work in Nunavut are familiar with the joys of simultaneous interpretation or consecutive interpretation. The interpreters were vital in making sure that information about restrictions and information about changes particularly were made and they were clear and understood. Similarly, your communications department is invaluable during one of these emergencies because they're the ones who have to take what the CPHO has ordered and put it into a one-page infographic they can give the CBC, or they can give to the Nunatsiaq, or they can explain, or something, put it in language the Premier or the Minister of Health or the CPHO can explain during one of those briefings. It was during those briefings when we got such wonderful quotations and bon mots, such as "now is not the time for vigilantes," which I think was a highlight for me. So a declaration of public health emergency lasts for 14 days, but again, it can be renewed every 2 weeks. We went through several ministers of health during COVID, and it was the minister would renew each time. And again, it could be a public health emergency for all or part of Nunavut. And there can be different levels of restriction depending on the level of the public health emergency or degree of public health emergency in different communities. So for example, we had our first outbreaks of COVID in Senekilowak and Arviat. So the highest levels of restrictions were in those communities, but in the other communities where there were no cases, there were no active cases, the restrictions could be lighter. And we had varying levels of restrictions at varying times of the pandemic. It's important to note that the pandemic was declared in March of 2020. We did not get our first positive confirmed case of COVID in Nunavut till November. And then we didn't have our first positive case in Iqaluit until April of 2021. So those measures, even though they were not always popular, were in many respects effective. So CPHO has quite an extensive list of powers to respond to public health emergencies. And they're set out in Section 41 of the Public Health Act. Again, I'm not going to read that to you. But they include the power to authorize qualified persons to render aid and assistance. This actually proved useful during COVID because all of the people who are trained to give injections when we needed to do public vaccination clinics and the nurses were overwhelmed, we could bring in other people who had that degree of training and they could be authorized to do that kind of support. Again, there was a lot of procurement during that time, medical supplies and equipment primarily, but we had an entire network of what we informally called swab air, which is where the tests in all the communities were collected and delivered to Rankin and Iqaluit, where the testing was conducted. So there was a network there. Also, the distribution of vaccines when they became available involved a lot of charter flights. There were agreements with the airlines to provide essential services to maintain essential levels of service during COVID, because this is a territory we absolutely can't have the planes parked in the hangar. Medical travel still had to keep going, and essential travel and flying in of materials and supplies had to keep going. It's a power to enter into agreements with other governments and agencies, which we certainly do, and during emergencies, and we acquire or use real property. That one did not come up during COVID, but we had to restrict travel. I mean, that's the part that people will probably most remember about COVID and Nunavut is that we had travel restrictions where you had to spend a couple of weeks until vaccines were available anyway, you had to do a couple of weeks in isolation in a departure gateway in the south. Hold a pin on that when we get to the charter slides. And there are other measures necessary to address public health, such as limits on gatherings and closures of facilities. I remember the day when CPHO instructed me to draft the order restricting things that happened in licensed establishments, that we couldn't have singing, dancing, karaoke, anything like that. And I just remember saying to him, Dr. Patterson, are we finally living in that town from Footloose? And for the future, for the remainder of that public health emergency, Footloose rules were sort of our shorthand for that level of restriction. So CPHO orders have to be made in writing, and they must be published in all the official languages. They do not require publication in the Gazette, but they do require publication. So it was with COVID, it was a combination of putting things up on the website. Also, for the orders in communities, they were sent to the community, to the public halls, and they were posted in multiple different ways. And the CPHO and others did presentations on community radio. Those are basically to get the message out in all the official languages. So COVID was the big public health emergency. That's the first and so far only declared state of public health emergency that we've had. There could be others. And I think global public health emergencies aren't going away, and they're not going to get better. I think they might come more closely together, just because as the world becomes more interconnected. And I think every public health expert will say that the last big global earth-shattering public health emergency was the influenza outbreak in 1919, where many of the same public health measures came in, were used. Mandatory masks, limits on gatherings, that kind of thing came in. But that was 100 years. It may not be 100 years before the next one, unfortunately. If that happens, if there's a declaration, you will see me in the lounge at the Iqaluit Airport. I've done one. I don't know that I could do another. So, this being Nunavut, being a territory and not a province, there are always issues about paramountcy and jurisdiction, because again, all acts of Nunavut, of our Legislative Assembly, are subject to any other act of Parliament. There's always that potential for conflict with federal law. But territorial laws of general application are going to apply throughout the territory, including to federal landed institutions, except where there would be a conflict with federal law. And with COVID, sometimes we intentionally wrote the restrictions such that we would not create a restriction, or we wouldn't create a paramountcy issue, such as when Parks Canada has the national parks, which they administer. They adopted our restrictions. Parks Canada agreed to just follow suit with the territory, but we had an order in subject to any directions or specific orders of the minister responsible for Parks Canada. So the parks could go stricter or not, but they could do their own thing because it is their jurisdiction in territorial park, in national parks within Nunavut. And in many cases, the federal and territorial laws are going to cover different aspects of the same issue. I have a slide with a nice little diagram coming up on sort of one of those examples. And then there are other exceptions, such as the court. Court is a separate branch of the constitutional hierarchy. If you go back and look at the old COVID orders, you will see that any of the orders about social distancing and gatherings specifically exclude the court, because the court has the power to make its own rules. And the court has the power to make rules about who comes in and out of their building anyway. And the Chief Justice of the Nunavut Court of Justice made a set of rules that governed what happens in the court during those times. Similarly, the Speaker of the Legislative Assembly has the power to control access to and from the Legislative Assembly, what they lovingly call the Legislative Assembly precinct, which is the Legislative Assembly building and the parking lot behind it, and any other building that's in the sort of jurisdiction of the Assembly. We had restrictions and exemptions for travel for the MP and senator for Nunavut, because they had to be able to get to Ottawa when Parliament started sitting in person again. And we did that without being asked. We just did it to put it in because we didn't want to create a situation where I would be getting an angry letter, or the CPHO would be getting angry letters from the law clerk from the Parliament of Canada. And we didn't get it, but there were exemptions to allow government to keep functioning. So we respect sort of those distinctions. But here's an example of where federalism rears its head. The Public Health Act says the CPHO, in a time of a public health emergency, can restrict travel to and from any part of Nunavut. That to and from was important. There were never any restrictions leaving Nunavut. All of our restrictions were about travel to Nunavut. However, entry to Canada is clearly a federal head of power. And particularly under the Quarantine Act, screening for communicable disease at the border is a federal head of power. Now, all international travel during COVID was restricted to about 5 international airports across Canada. Iqaluit is an international airport. We were not one of the airports of entry. But the Minister of Foreign Affairs, or Global Affairs as they call it now, made a temporary order declaring Iqaluit to be a port of entry during COVID to allow a fishing boat crew to change. And they did that without telling the CPHO. So suddenly when these fishing crews came into Nunavut, they set foot on the dock and they entered Nunavut, they became subject to our orders. And we had to scramble to deal with that fairly quickly. Similarly, aviation and shipping are federal heads of power, and we rely on sea lift and we rely on planes. So there were lots of rules about what happens on the plane and what happens at the airport during COVID, with their various federal travel restrictions and the territorial restrictions. So we tried to tailor our orders such that they wouldn't conflict. So basically anything that happened in the airport was our problem, and anything that happened on the plane was the feds. And we both made orders to airlines requiring contact tracing and providing other information. So there were areas where our orders had to match, or they had to be consistent with each other, particularly with things like temperature checks and when you were allowed on a plane and when you would be allowed into Nunavut. We tried to make those match as much as we possibly could, just so there wouldn't be inducing errors that were unnecessary or creating potential conflicts. So this is the bit that kept me up nights during COVID and during any one of these emergencies. It's that naturally, during COVID and other emergencies, there is a potential for infringement of charter rights. I think we've written more on the law of mobility, Section 6 of the Charter, in the last 3 years than we did in the previous 30. As a friend of mine from law school who works in the federal government said, we're adding new branches to the living tree on mobility rights in Canada. And there were cases challenging provincial and provincial orders. Notably, there was a Taylor versus Newfoundland and Labrador, which upheld very similar travel restrictions to what we had in Nunavut. There were challenges to the federal vaccine mandate. There were challenges to provincial restrictions based on mobility, freedom of assembly. Certainly, we saw the cases with on gatherings and particularly exercise of religion when exercise of religious services and things were restricted due to personality, or you couldn't sing in church, or you couldn't have laying of hands. You had to stay so many meters apart. There were restrictions. Incidentally, one of the hacks we came up with for this in Nunavut when determining how big a gathering could be, we set the minimum gathering at 5. That any of these restrictions that we put in, we tried to tie to something else, because again, we were inventing a restriction, and sometimes we didn't have a precedent to go on. So we were trying to tie it to something else. And the number of 5 came up partly because the CPHO said public health wise, you're probably, if you're staying 2 meters apart, it's not a risk, not a significant risk to public health, but also it's the bare minimum number of people in Nunavut we need for a wedding. It's the efficient, the happy couple and 2 witnesses. It's 5. That's the bare. So that's one of the reasons we set it that way, because it just sort of made, we're not trying to create other problems. But there were also challenges around life, liberty, security of the person. Those challenges were largely overturned in Newfoundland and Labrador and Ontario, etc. We were also on guard against concern about unlawful detention, particularly when you're ordering people into isolation. And during the public health emergency, certain things about having reasonable probable grounds to order somebody into isolation don't necessarily apply in the same way. So the fact that everybody had to spend 2 weeks in a hotel and subject to certain restrictions on their liberty and freedom created some concerns for us. So everything that every restriction or infringement on charter rights has to withstand a charter challenge as a reasonable limit. And that is one of our roles as government counsel. And when we are advising officials doing orders, is to make sure that it would withstand the Oakes analysis, that it's established by law, that it's the impairments tied to restriction, that it isn't punitive, that it withstands that Oakes test scrutiny. And we also are aware that Canada has signed certain international conventions which have the force of law in Nunavut, such as the UN Convention on Civil and Political Rights, which have other restrictions accommodated. That was particularly useful for us on mobility because there was so little jurisprudence on mobility other than for employment. Most of the mobility cases in Canada are about moving to another province or territory for a job or to seek employment elsewhere. This was just movement in general. And so the UN Convention was useful to us there. And provided interesting commentary. But there's some other constitutional considerations in addition to the charter that we have to consider when we're doing restrictions, particularly when we were making restrictions on gatherings and restrictions on activities. We were always cognizant that there were hunting and harvesting rights and other traditional rights guaranteed in the Nunavut Agreement that we did not want to touch and we did not want to infringe. And similarly, there were exemptions about travel. I mean, caribou don't care where the border is. So if you're going hunting and you're on the snowmobile and you end up over in the Northwest Territories to get your caribou and then you come back, that's not travel and you don't need to report to an isolation hub for that. We created clear exemptions for this. And there were clear exemptions or exceptions for Inuit exercising their rights or participating in traditional activities. We had similar language, particularly for areas around Sanikiluaq, where the Nunavik Inuit have rights under overlapping claims, and the Cree. And so we created exemptions for this just to make sure that we weren't trampling on somebody's constitutional rights without talking to them first or without making sure that we were authorized to do so. So we did make sure we tried to tailor those restrictions. And again, there is an interesting case out of Manitoba that I just put here as something that you might find interesting. That long-term preventative measures for natural, and this was in the natural disaster capacity, may engage consultation obligations where there might be negative long-term impacts on lands and rights. In Manitoba, it was the Métis and and certain First Nations that had a claim because it was about the Manitoba floodway and the extension of the floodway. And the deciding to let certain farmland or what the provincial authorities consider to be vacant and unused land to allow the floodwaters diverted away from Winnipeg to flood that land. And of course, that may contain sewage, it may contain other things. It may affect that soil, it may affect the wildlife living there, whatever. So the Interlake Reserve Tribal Council have pursued many years of litigation because these things always do take multiple years. And the Manitoba Court of Appeal did ultimately say that there may be measures where this could trigger consultation obligations. So this has not been a live issue in Nunavut. So I'm not saying that this is something we've given thought to, but there is the case law that's emerging, and it's something the people doing emergency law continue to watch, continue to follow. So this is where I put in my shameless plug for future learning opportunities. A couple of years ago, I was part of the first ever certificate in the law of emergencies from Osgood Professional Development. And I wrote in the comment box that, why are you doing a presentation all on provincial and territorial laws and not a single government lawyer is involved? And that, of course, was just me volunteering for work because I found myself on the faculty. So this year I am participating in a one afternoon program. It's 1 to 5. It's online or in person if you want to go to Toronto, but it's on Zoom if you don't, on the law of emergencies, specifically on jurisdictional challenges and the federal court rulings about the border challenges and about the declarations of the federal restrictions. It is put on by Osgood Professional Development. Is on April the 29th. I am part of one of the panels, along with some esteemed colleagues who work for municipalities and work for the Ontario Ministry of Attorney General and work for other large firms. And there is a detailed panel discussion, including with the lawyers who argued some of those federal cases. So that's coming up on April 29th. Again, you do have to pay for that. Sorry, that one's not free. I can't do anything about that, but it's interesting. And if you are interested in learning more about the federal side than what I've very, very much touched on today. So that is the end of my formal presentation. The slide, I have no problem with Rebecca sharing the slides to anyone who's registered. There's nothing here that isn't public domain already. But again, if you have any questions, we do have some time. So I think Rebecca is going to moderate those. But I'm going to stop sharing my screen because you don't really need to see my contact information all the time. You know where to find me. I'm at the GN. And if you're one of those people who doesn't like asking questions in front of the whole class, you can always email me later on. So thank you very much.
And thank you again, John. I have just put my email address into the chat. So if anybody does want a copy of the slides, you can please email me and I can send it to you. And that might be the easiest way to go about this. Do we have any questions?
I just wanted to thank John for an incredible presentation and compacting all of what was a very memorable time into such a short presentation. Very, very excellent. I just, listening to it, I was reminded of some of the not so happy things that happened during that time. And I'm so glad that we've passed through that time, and hopefully we'll never have to revisit it again. But I really thank John for the presentation and also for his service to Nunavut during that time. I'm sure was very much appreciated by the government.
You would think. But thank you very much for that. And I'm not taking credit for the entire pandemic response in the GN. I was one of people, I was acting director during the early days of pandemic. And I said, if we're going to be playing with the Constitution and potentially violating people's rights, I don't want it to be one of the legal counsel who bears the brunt for this. I'm the boss, I'll take the heat. So that is, and because I had worked on drafting the Public Health Act with my esteemed colleagues down the hall in Legislation Division, those of you who remember Susan Hardy, those of you on the call remember the great Susan Hardy, who was Director of Legislation. When I started working at the GN back in 2010, she said, I'll make a drafter of you one day. And Norman, who was my boss at the time, said, no. So during COVID, after I'd written my umpteenth order on social gatherings, I had to reluctantly write Susan Hardy and say, you know how you were going to make me a drafter? Well, finally happened. But there are lots of us worked on that. Every piece of the puzzle in responding to COVID required a response. I see a hand up.
Daniel? Do you have a question?
Thank you, Rebecca.
Okay.
Hi, John. Nice to see you again. Thank you for an excellent presentation. Very, very informative. I was just curious to get your opinion on Nunavut's preparedness for the next pandemic or pandemic-like situation, and if you are comfortable commenting on it, how you think the country is positioned to respond to the same.
Good question. I think we're going to be better off next time around because we actually have templates for things now. Whereas in March of 2020, we had nothing. We had an act. We had a brand new act and regulations that went with it. And we did, contrary to popular opinion and what people might have commented in the Nancy Act, we did have a pandemic plan. But according to Mike Patterson, our chief public health officer, he's told this to the ledge, so I'm not breaking any promises or privilege. He said the pandemic plan was completely backwards for what we needed based on what we knew about COVID at the time. So it involved bringing everybody to the school gym and doing mass testing, which would have been a gathering well over the size, and we didn't have the capacity to do that many tests. So we had to come up with something different. So we were relying very much on the help from our friends. And that is the good part about working in a federal provincial country such as ours, is that there was a great amount of cooperation at the local level, that there was sharing of templates, there was sharing of documents. For example, we did a common travel area. I know everyone called it a bubble in the news, but I just couldn't bear to write that in the order. So I called it a common travel area, because I was basing it on the Schengen in the European Union and the Australian, New Zealand arrangement. Because if I ever had to explain this to a judge, I wanted to say I based it on something real in rooted in legislation. Um, we did a common travel area before Nova Scotia and New Brunswick did. There was the maritime bubble or the Atlantic bubble. If you look at the Nova Scotia orders from those days, the language is very similar to ours, and there's a reason for that. So to answer your question about how we'll handle it next time, I think the emergency response, there was an Auditor General's report, particularly into our vaccine rollout, and the Auditor General was somewhat critical of how we did some of the rollout. And I think the health department has agreed to take that on. But in terms of the legal response, we've got a suite of documents and templates ready to go, including there is a memo in our document management system called How to Write Public Health Orders. So we actually have desk procedures, which we didn't have before. And I think on the civil emergency side, CGS does a very good job. I know I'm their lawyer, and I have to say this, but they actually are very good at responding to things very, very quickly. And the fact that we got those isolation hubs, which I know everybody loved so much, but we got them up to snuff in 72 hours. The federal government took 3 weeks to do theirs. So and so we did that. I think we'll be better at the response. We'll be better on that, but it will depend on the nature of the virus or the nature of the event, on if we're able to handle it locally or not. Our goal, and Mike Patterson said this in the very first declaration, is it's not a matter of if, it's when COVID comes to Nunavut. All we were trying to do was slow it down, because we could have very quickly overwhelmed the hospital. And any COVID death is a tragedy. I'm not minimizing any of that, but we kept the death rate for COVID in Nunavut was under 10. So in a very vulnerable population, I think the restrictions did what they were supposed to do. Nationally, time will tell. I think we always do learn from these things. And we'll see what the response to the Rouleau Commission and some of the others, but Public Health Agency of Canada will definitely be monitoring and reevaluating and finding things out. What is good news for me anyway, although it is more work, is there's a new group of federal, provincial, territorial lawyers who specifically advise on this stuff. And we are having our first meeting very soon. So we're going to keep the conversation going post-COVID. So we may be able to deal with some stuff before it happens or have some better preventative measures. So I hope it's going to be good.
Thank you. Thank you for that very informative response. Thank you for a great presentation again.
Good to talk to you again. Anybody else? Can I use this time to shamelessly plug our next presentation, Rebecca?
Absolutely. That would be perfect.
All right. So in about 2 weeks from now, you can sign up and listen to me talk again with a sandwich. You got to bring your own sandwich on the law of consent to medical treatment and on the capacity for medical treatment in Nunavut. We are one of the few jurisdictions in Canada that does not have legislation. We don't have a Healthcare Consent Act. We don't have specific we don't have advanced care directive legislation in the territory. So we are all sort of in the realm of common law, with the exception of mental health, which has a statutory regime such as it is. So we're going to take some time and we're going to talk about consent to medical treatment. I'm going to be giving you basically the same information that I give the doctors and the healthcare professionals, because part of my job as senior counsel is to teach and is to actually do things like this. This is my job description. And it's one of the things that I really enjoy. And in getting to go and talk to healthcare workers about the medical legal responsibilities is one of the things that I get to do. In fact, just yesterday, I was up talking about privacy and telling my usual scary privacy stories. But what's nice about it is that the questions I was getting back were really informed and were really interested, because it's just building on stuff we've been talking about on and on. So we're going to talk about capacity and consent. And I have got some tips on how you yourselves can protect yourselves, but also advice you can give clients on sort of how to make sure that your views get reflected and respected by healthcare providers. So that's coming up, I believe 17th. It's very soon anyway. The slides are already done. So they're ready to go, and I'm happy to help out. And thank you very much for participating, and hope the emergency law conversation carries on. And you know where to find me if you have follow-up questions. So thank you very much.
Wonderful. And thank you again, John, for being here. That there is no remuneration, but my understanding is Nalini is sending you swag. So get excited. This is what we
A
have.
Law Society coffee cup. Yeah. No,
You might even get 2 coffee cups, one for each hand. So thank you again. And thank you everyone for attending. And again, yes, John is doing a further presentation in a couple of weeks. And we are developing a CLE calendar focusing on lunch and learns for the year. And so we'll be rolling that out. And please do email me if you would like a copy of the slides. And I look forward to seeing you folks next time. So thank you so much.
all right. Thanks, everyone. Have a good day.
And I think we might just wrap up then, and from a humane perspective, everyone can have a health break before they head to their next meeting.
All right.
All right,
Talk to you
take
soon,
care.
everyone. Bye.
Bye.